Welcome to our deep dive into the harsh reality behind so-called quick immigration waivers for long-term residents married to U.S. citizens. To smoothly transition into today's content, I'll start by stating the goal: to replace myths with accurate expectations and a clear roadmap. We will unpack the multi-year waiver stage, the consular interview abroad, and the risks of administrative processing that can turn a hopeful 30-day plan into many months away from family. Let's begin. Now that we've set the stage, let's clarify who this video is for. This is aimed at long-term U.S. residents who entered without inspection or accrued significant unlawful presence and are now married to a U.S. citizen. It's especially relevant if you're considering consular processing and an I-601A Provisional Waiver. With that in mind, we'll add an important disclaimer next. Before moving forward, a brief but essential disclaimer. This video is for general educational purposes and does not constitute legal advice. Each immigration case is fact-specific, and outcomes depend on your history, documentation, and the agencies involved. Always consult a licensed immigration attorney before making decisions, especially about leaving the United States for consular processing. With that established, let's walk through our agenda. To guide you step by step, here's our agenda. First, the big picture process map. Second, the multi-year I-130 and I-601A phase. Third, the myth of the 30-day return. Fourth, administrative processing risks. Fifth, a preparation checklist. Sixth, short quizzes. And seventh, key takeaways and a wrap-up. Let's zoom out and see the full journey next. Building from our agenda, let's map the end-to-end journey. First, you need two critical approvals before ever leaving the U.S., the I-130 Petition and the I-601A Provisional Waiver. Once both are approved, your case moves to the National Visa Center for Fees and Civil Documents. Next, you travel abroad, complete the medical exam 1 to 2 weeks before your consular interview, and attend the interview itself. The results can include immediate approval, a 221G request for additional documents, administrative processing involving extended checks, or, in some cases, denial that may require further waivers or legal intervention. With this roadmap in mind, we'll now examine the multi-year phase that most people underestimate. Transitioning from the overall map, let's start with the I-130. The I-130 petition establishes your qualifying relationship to your U.S. citizen spouse. You'll submit evidence of a real, ongoing marriage such as joint finances, shared residence documents, photos over time, and affidavits from people who know your relationship. Some cases get interviews, while others are waived, depending on agency policies and the strength of the file. Timeframes vary significantly by service center and workload, often taking many months. Once the I-130 is approved, attention shifts to the I-601A Provisional Waiver. Continuing to the pivotal step, the I-601A Provisional Waiver addresses the unlawful presence bar by demonstrating extreme hardship to a qualifying relative, typically a U.S. citizen or lawful permanent resident spouse or parent. Children do not qualify as qualifying relatives for this waiver, although their circumstances can sometimes be part of the hardship narrative. Evidence can include medical records, psychological evaluations, financial documentation, proof of dependency, and relevant country conditions. Critically, this stage often takes 3 to 5 years to adjudicate, and leaving the U.S. before approval risks triggering a 10-year bar without a guaranteed return. With the waiver approved, you proceed to NVC and then to the consular phase abroad. Next, to ground expectations, here is an illustrative timeline table. The I-130 often takes several months to over a year. The I-601A waiver commonly ranges from 3 to 5 years. The National Visa Center phase for fees and documents may take 1 to 6 months. The medical exam is scheduled 1 to 2 weeks before the interview. The interview occurs on a set day, but the outcome can vary. If administrative processing is triggered, it can last months or longer. These are ballpark figures. Your results will depend on your case specifics and agency backlogs. Now, let's visualize this journey as a timeline. To further illustrate duration, this timeline lays out major milestones. I-130 filing and approval, I-601A filing and a lengthy multi-year adjudication window, the NVC phase for fees and civil documents, travel abroad and the medical exam 1 to 2 weeks prior to the interview, the consular interview itself, And then possible branches: immediate approval, a 221G, request for documents, or administrative processing that can add months. Ultimately, if approved, you receive the immigrant visa and enter the United States for inspection and admission as a permanent resident. With the timing in view, let's confront the 30-day myth head-on. Moving from the timeline to expectations, the 30-day return scenario is a best case and not guaranteed. Ideally, you arrive about 2 weeks early, complete the medical, attend a smooth interview, and the visa is printed and returned quickly. However, in practice, delays can arise with medical result processing, document verification, visa printing capacity, or courier pickup logistics. The most significant risk is administrative processing, which can add months abroad. That brings us to what triggers administrative processing. To compare perceptions with facts. First, the expectation of a 30-day turnaround is sometimes possible but never guaranteed. Contingencies must be planned. Second, marriage to a U.S. citizen is important for eligibility, but does not exempt the case from security and background checks. Third, any arrest history, even without a conviction, can prompt additional review and delay. In short, optimism should be balanced with preparation. Building on the reality check, administrative processing can be triggered by several factors. Arrest history, whether or not it led to conviction, often triggers deeper scrutiny. Immigration violations, such as prior deportation orders, misrepresentation, or fraud findings, are major red flags. Security name matches or ambiguous records can lead to extended background checks. Finally, missing or inconsistent documents lead to 221G requests and slowdowns. The pie chart is illustrative only, and not based on fixed proportions, but it highlights how multiple factors can contribute to delays. Next, let's move from risks to preparation. Shifting to action items, start with professional guidance from a licensed attorney. Next, plan for the possibility of months-long separation, including budgeting and family logistics. Prepare a well-documented I-130 and a comprehensive I-601A hardship packet supported by medical, financial, and psychological evidence as applicable. Gather records such as FBI background checks, court dispositions, and relevant immigration files via FOIA when needed. Ensure civil documents for NVC are correct and translated. Schedule the medical promptly when eligible, and understand local procedures. Practice for the interview with clear, truthful responses and well-organized originals and copies. Finally, set up contingency plans for childcare, employment, and finances in case administrative processing extends your time abroad. To reinforce these points, let's do a quick knowledge check. Here's your first question: true or false? You should leave the United States for your consular interview as soon as your I-130 is approved, even if your I-601A is still pending. Option A, true. Option B, false. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is false. You should not leave the United States before your I-601A waiver is approved. Departing prematurely risks triggering a 10-year bar without a guaranteed ability to return. With that clarified, let's apply these ideas to real-world scenarios. Continuing with application examples, a person with a clean record whose only issue is unlawful entry generally has a better chance of a straightforward outcome after the interview. Someone with an old arrest, even if dismissed, can still face administrative checks and should obtain certified court dispositions. Individuals with prior removal orders or misrepresentational findings should anticipate intense scrutiny and plan carefully with counsel. Finally, missing documents at the interview often result in a 221G request and delays. Before we summarize, let's do one more short quiz. Second question: which situation is least likely to trigger long administrative processing delays? Option A, prior fraud or misrepresentation findings. Option B, a recent arrest with an ongoing case. Option C, a clean record with only unlawful entry or unlawful presence. Option D, a prior removal order. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is option C. A clean record, where the only immigration issue is unlawful entry or unlawful presence, generally faces fewer complications after the interview compared to cases involving fraud, pending criminal matters, or prior removal orders. Now, to cement everything, let's capture the key points in Markdown form. As a practical wrap-up in Markdown form, focus your hardship case on documented medical dependencies, financial interdependence, psychological impacts, and relevant country conditions. For travel planning, arrive 10 to 14 days before the interview, complete the medical exam early, bring original documents with certified translations, and prepare concise, truthful responses to expected questions. A useful tip is to build your timeline and budget, assuming a longer stay abroad. Also, keep digital and physical copies of your entire file in a clearly labeled binder. Next, we'll summarize the key takeaways. Here are the essential takeaways. Do not depart the United States before your I-601A approval. Expect a 3 to 5 year time frame for the waiver stage by itself. A 30-day return can happen but should not be assumed. Administrative processing can add months to your time abroad. Comprehensive preparation and documentation provide the best chance for a smoother process. Now let's wrap everything up. In summary, this journey is a marathon rather than a sprint. Build a strong evidentiary record, plan for contingencies, and keep yourself informed while remaining patient. Most importantly, work with a qualified immigration attorney who can tailor advice to your unique situation. Finally, here's a quick closing note. Thank you for watching. If this video brought clarity, please like, share, and subscribe for more deep dive guides. In a creative spirit, imagine helping someone avoid a costly detour. Share this with them today, and tell us in the comments, what is your biggest question or worry about the waiver stage? Your thoughts can shape our next video.